this is a new topic, and I think you all are aspirants for the forthcoming examination in this month. I am sure you have studied more than me, and I will focus whatever possible to make it easy the subject of medical negligence. Now, first thing, because this orientation is focused on your forthcoming exam, so I would like to give you some hints in between how the questions may be posed in the exam. You are aware in the Consumer Protection Act 1986, the previous act, the medical services were included. And there was misunderstanding between the doctors, amongst the doctors, that in the 2019 Act, the medical services are excluded. You may get the question or the multiple choice whether under CPA 19, medical negligence is excluded. Remember, it is not excluded. There is a judgment of Honorable Supreme Court on 29th April 2022 that it upheld the judgment of Bombay High Court that doctors and healthcare services are not excluded from the CPA, new CPA 2019. The Honorable Chief Justice, Mr. D.Y. Chandrachud, he held that the definition of service is wide enough under the Act. Therefore, the services of the medical professionals are not excluded. Then if they want to exclude, the Parliament, if it wanted, it should expressly mention in the Act that these services are deleted, but that has not happened. And moreover, there is a judgment of larger bench, that is VP Shanta's case. I think it was in 1996, 94 or 96, where from that judgment, all the medical services are brought under purview of Consumer Protection Act. So unless the judgment is set aside by the larger bench now, till then, the services of doctors are under CPA. So this, you may get any short note or any question or write any judgment. You will get the problem that the patient was treated in the government hospital and it was a free service. Then whether, then write the judgment on this. So you have to apply your mind. The VP Shanta's case has discussed more about the medical negligence and the liability of the doctors or the hospitals, which come under purview of service for consideration, partly paid, or there are few charitable hospitals, if they are doing totally free, then they are not covered. So I will not touch those issues. You go through the service and what is the jurisdiction also. Let us touch upon the Consumer Protection Act. You remember there are two things, service provider and the other end is consumer. Now the Consumer Protection Act at the center I have placed, it relates to goods purchased and it relates to services availed. So at the one end, the consumer is there. He will avail or he will purchase the goods or avail the services. And if there is any defect, if there is any deficiency, then he will approach under CPA to the adjudicatory machinery, that is consumer commissions. So you all are aware what are the different consumer commissions, district and its jurisdiction under new Consumer Protection Act. So I'm sure the previous lectures might have covered all these issues, basic issues on the Consumer Protection Act. Now let us see what is negligence. You may be asked any short note or a question. I think your paper consists of some theoretical question also, in addition to the multiple choice. So what is negligence? see both the words, omission and commission, very confusing words. So negligence is an act of omission to do something. So it is related to, it is generalized statement. What you are supposed to do, you are not doing. That is omission. And what is commission? What you are not supposed to do, you are doing. That is the act of commission. If there is any act of commission or omission, that amounts to negligence, remember. So, see, the act of commission would do or doing something which the prudent and reasonable man would not do. So the act, some prudent person, he will not do. If he commits, or that is the act of commission, it will be construed as negligence. Now let us see, you may be asked, one patient is there and under medical, for the medical negligence liability, what are the remedies available for the patient or the complainant under consumer protection, for the medical negligence. So remember, medical negligence is very wider term. The doctor's liability will be decided. The patient can exercise his right, or patient can approach the following 4 authorities or under 4 channels, legal channels. Number 1, he can exercise the criminal law, that is criminal liability. Then civil liability is there. Under civil liability, there are there are 3 things. One is contractual liability. If the doctor or hospital breach the contract, then definitely the patient can file the complaint. Then other is CPA 2019. Previously it was 1986. Now we are dealing with 2019. And secondly, he can approach the PRB, means professional regulatory bodies. So remember, he can exercise the legal remedy against the doctor or hospital under criminal law, under civil contractual law, under Consumer Protection Act, and through the professional regulatory bodies. Now let us see the constituents of negligence. I have referred this 4D in many judgments. Even the Honorable Supreme Court also quoted 4D. And you should remember, or if you come across the question, what is medical negligence? First define, it is the act of omission or act of commission the doctor does. Then what are the constituents, ingredients of the negligence, medical negligence? Remember the 4D, there should be legal duty of care from the doctor. Suppose if he is a simple MBBS and or if he is an Ayurvedic doctor and some patient will go there for the chest pain, whether he has a duty. So the ingredients are, first thing will be, there should be legal duty of care for that person. Suppose he is not a doctor at all, or he is a PhD doctor. By seeing the board PhD doctor, if the patient goes to him, whether he has any duty? No, he has no legal duty of care towards that patient. Then second, if there is a duty, whether there is a dereliction of the duty. Dereliction means breach. Whether the doctor breached his duty of care. First thing, yes, doctor has duty of care. Then dereliction, the breach. And what is the next? The next is the breach shall result into direct injury. The breach, if the doctor commits any breach, that should result direct injury. That is known as causa causans. Means it was the primary or it was the proximate cause of the injury. You cannot say the doctor has prescribed some tablets and those tablets have made me, there are some reactions, but it has direct nexus with those tablets which will evoke the drug reaction. If there is no scientific basis, then it is not a direct cause of injury, though the doctor has prescribed the medicines wrongly. Then the 4th D is damages. So the complainant has to prove because of all three Ds, I suffered the damages. No doubt, there is a damage. Damage is again a wider term, physical, mental, and financial damage also, because patient will incur unnecessary financial loss. This is also considered as a damages. So remember the constituents or ingredients of negligence. The complainant, if the complainant or the patient want to succeed in his claim or in his complaint, he must prove all the 4D. If 1D is missing, then the court or consumer commission will not fasten the liability of medical negligence. Now the liability, how the doctor is liable? These are the ingredients. Now these are the ingredients. What the doctor should understand? The doctor should understand if he fails in his duty of care, everything is revolving around, see the medical negligence. If you want to write a question, essay question also, remember few words, the definition, the ingredients, then reasonable standard of practice. And fourth is doctor-patient relationship. You have to explain what is the doctor-patient relationship. When there is a breach in doctor-patient relationship, it will spark the litigation of medical negligence. So now if the doctor fails in his duty of care while deciding whether to undertake the patient or not, if he decides what treatment shall I give, it was his duty to decide what I have accepted the patient, now what shall I do? And third is actual administration of the treatment. This is the LB-Joshi's case. You might be aware of the LB-Joshi's versus Trimbak Bapu Godbole's case. It has discussed, Honorable Supreme Court has discussed, what is duty of care? One, whether to accept the patient. Second, after acceptance, what treatment shall I give? And third, actually what I am giving, whether it was correct. So this LB-Joshi's case also you can go through. See this. These are the duty of care that LB-Joshi's case has discussed in detail. Duty of care at different stages. Stage 1, deciding whether to take. It is again repetition. Yes. The next question, very important in the medical negligence topic, is Doctrine of Consent. What is consent? Every patient has right of self-determination, and there is a personal autonomy also. Patient had every right. Let me die. It is his right. He may reject to give the consent. Doctor cannot force. Forcible consent is not admissible in the law. Doctor cannot force undergoes so and so treatment. His duty is to persuade the patient or persuade the complainant or patient's relatives that these are the things I want to treat. These are the available things. I will administer this. This operation is better. This medicine is better. Finally, patient has to consent for that. You have to say, you have to explain in detail about all the ingredients of consent. That is known as Doctrine of Consent. I am going to what are the ingredients of informed consent. I will discuss that. Now, just last line, you can mention if you may get a question on informed consent also. Informed consent is also very large topic. You need a lot of elaboration. The consent, remember, in the informed consent, you may be asked in the multiple choice, which is the landmark judgment of Honorable Supreme Court on informed consent, the Samira Kohli's case. And what is the latest judgment on informed consent? Remember Montgomery's case. The Montgomery's case versus Lanarkshire Hospital in UK. It was decided in 2015. And that has set new landmark but there is a flavor of Samira Kohli in that judgment. Remember. So in the consent, don't forget to write the evolution of consent. What are the different types of consent? There are the different types of consent, implied consent, then implied consent, and informed consent, then negative consent. There are so many. Now let us touch. You may get a full question on informed consent also. So what is informed consent? If you go through Samira Kohli's case, Honorable Supreme Court discussed 9 to 10 points on the informed consent. What is to be informed, what shall not be informed, and what constitutes the informed consent. The informed consent is, I have made it very brief. If you remember this brief, you can elaborate the question. You can write a full page question answer of this question, informed consent. Number one, it is the benefits of treatment. So as you are a judge, you are going to be a member of the commission or president of the commission. What you will see? What is the informed consent? Now the ingredients of informed consent are brand. Remember the brand word. Number one, the doctor shall intimate, doctor or hospital shall inform the benefits of treatment. Second, the risks of the treatment, to whom the patient or his attendant. It is the duty of hospital to take an informed consent before any procedure. Now you will come across what is to be done with the OPD patients. For the OPD patients, it is known as implied consent. When the patient enters in the chamber of the doctor, the patient accepts the doctor, yes, let the doctor examine me. There is no written consent. It is an implied consent. And as soon as the patient approaches the OPD, doctor's chamber, and doctor accepts the patient, yes, I will examine him. That is known as implied consent. There is no need of written consent. So like that, the informed consent, it should be in the written form. It should be signed by the doctor and his witness. It should be signed by the patient and patient's witness, or the close relative. If the patient is unconscious, who will sign? His close relative shall sign along with one witness. So what are the ingredients now? The benefits. The consent should explain the benefits of treatment, the risks of treatment, whether there are any alternatives. You might have seen, you may come across, the doctor will say, there is one operation you can do by open surgery. That is a laparotomy. Open surgery is laparotomy. Doctor may say there is alternative. I can do through the tube, that is known as laparoscopy. So these are the different alternative methods. He will explain. Under this, these are the benefits, these are the risks. Under laparoscopy, these are the benefits. Then the choice to give the consent, it is up to the patient. Patient should be explained, and then the patient's autonomy will come, personal autonomy. He will decide whether I will go for this or that, or I will not go for anything. Patient may reject. You cannot force. But recording of this consent, you should write patient accepted. The doctor shall write patient accepted this mode of surgery or this mode of treatment. Now, no treatment. The duty of doctor or hospital is to explain there is no treatment also. So, because in the cases of terminal cases of cancers, terminal patient is seriously ill in the ICU. Now, definitely a doctor has to tell there is no treatment at all. So shall we go ahead? Because if you don't tell the patient, that will amount to unfair practices also. Then the last is documentation. You have explained everything, benefit, risk, but you are not documented. the doctor has not documented, and you don't find that document, then it is not a consent, though in spite you have explained everything. Then next is this is are you clear with the consent? Remember, you focus the question. I have told the organizers to circulate this slide. You will get this presentation and you can elaborate your question and answers. But in the question of medical negligence, you have to discuss all those points. If you want to score 100%, you have to discuss all the points. Now, after consent is taken. If suppose there is a negligence, then who is liable for the negligence? Whether the doctor or hospital or other person, who are the directors or some suppliers, because usually the knee replacement or hip replacement or angioplasty, all the suppliers, they supply the material. Whether the supplier is liable or cataract, the lenses are available. If the lenses are faulty, if the lenses are infective, the patient will develop endophthalmitis and he will lose his eyes also. So, doctor, hospital or others, it consists of this. Now, who is liable now? You read both the sentences, the contract of service and contract for service. Both the lines are very confusing, difficult to remember, but easy to understand, but difficult to remember. Even I will get confused while interpreting. Sometimes it will go reverse, vice versa. So remember, contract of service means if the doctor is working under some hospital, if he is a consultant there, it is not his hospital, then that is known as employer-employee contract. In that case, if anything goes wrong, if there is a negligence from the doctor, that time vicarious liability of the hospital will be there. Though hospital has no role, but why vicarious liability? Because hospital is earning from this doctor. So the hospital is equally liable or hospital is more liable for the act of doctor. So principle of vicarious liability, you may be asked the question, what is vicarious liability? So the master is responsible for the act of servant. Remember the word. The master is liable for the act of servants. That is vicarious liability. It is a contract of service. Then what is contract for service? It is an independent doctor. If doctor has an independent nursing home, he has treated and some negligence occurred, that time that is construed as the contract for service. It is an independent doctor. He is liable under if his medical negligence is attributed. Yes, this is the vicarious liability. Read carefully and prepare this answer also. The liability of the master in spite of absence of blameworthy conduct on his part. Second is negligence. Employee is responsible for the acts of his servants. It is again same. Then what is contributory negligence? This is the new terminology. Contributory negligence, that will be helpful for the doctors to reduce the claim. If the court is awarding 100%, if court finds there is a negligence on the part of complainant also or the patient also, that time the quantum of compensation will be reduced, drastically reduced to 50 to 80% also. So that is concurrent. It is known as also concurrent negligence by the patient, the doctor, resulting in the delayed recovery or the harm to the patient. So suppose doctor has advised you come after 1 week for follow-up. This is especially in the cases of renal stent. after the bladder operation or ureter operation, the urologist will put the stent, DJ stent, and he will tell that stent should be removed after 1 month. You come after 1 month because patient will never come. Because what patient will think, I got cured, so why should I go to the doctor? जब होगा तब जाएंगे हम डॉक्टर के पास. This is the attitude of patient, and on after 6 months or 7 months, there will be obstruction of the urine. The digestant will coil inside. It will coil inside with the intestine also. The patient will suffer intestinal obstruction. That time, if he approaches the doctor, then definitely the larger surgery will be performed. And that time, if such case comes, that is known as contributory negligence. I won't say it is a contributory negligence. There was no negligence of the doctor, I will say. But if there is any element of negligence on the part of doctor also, and patient did not follow. During Corona period, the doctor advised steroid. Steroid should be taken in the tapering doses. If the patient, because steroid is a ramban, you may be remember, steroid is a ramban. So a patient feel I am very comfortable, but doctor told take half tablet after 2 days. Why can't I take 1 tablet? So he will consume more tablet. That is detrimental, that is harmful to the patient. So he should follow the strict instruction. So if something happens to him, that time the hospital or doctor is not liable. That is the contributory negligence. Next terminology, what is res ipsa loquitur? What is res ipsa loquitur? This may be the short question or the multiple choice question. Res ipsa loquitur, the things speak on itself. The things speak on itself. There is no need. There is no need to prove the negligence. See the picture. The seizure is kept in the abdomen. The patient, after operation, they close the abdomen, close the pelvis, and after 4 days, patient complained of pain, continuous pain. Then they did the X-ray and found this. This is what you need. It speaks on itself the negligence of the doctor. So there is no need. Just yesterday, I have pronounced one judgment. Go through that judgment. It is a res ipsa loquitur. It was the IVF clinic, and there is a gross negligence which the bench has decided just 2 days back, and you can go through that judgment. What is res ipsa loquitur? The res ipsa loquitur articles left in the patient's body. Second is operation on the wrong side of the part of the body. Suppose there is you have to do operation on the right hand, but accidentally or by mistake, he will amputate the left hand. The famous case, the actress, her mother was operated in the US. The brain tumor was on the left side, but she was operated on the right side of the brain. This is very horrific. So there are many instances that things go wrong. That is res ipsa loquitur. Not operating in the time also. Suppose patient has come in the acute emergency, appendicitis, severe pain, burst abdomen, and the duty of doctor is to operate immediately. If he operates after 4 hours, 5 hours, then what to need now? There is no need to prove. The next important topic is the medical record. You may be asked what are the different types of medical record. Discuss what are the different types of medical record. You have to write all those things. It is the most confusing part for the medical professional, also the lawyers, also the adjudicators, the members sitting before the bench. So, what is medical record? Now, you should understand what it is. It is a document prepared by the hospital when the patient got admitted, from the time of admission till the discharge, whatever the documents, the written documents or investigation, reports, films, entire thing constitutes medical record. Then why is the medical record is necessary? Why you want to keep? Because of follow-up, because of statistics, because of proper treatment of the patient, entire medical record meticulously to be maintained. Then whose property it is? Medical record, there are some divergent opinions. Few people say it is a hospital property, few are patient's property. But in my view, I have decided or I have taken it as it is a property of patient because patient pays for that. When the patient pays for the medical record or entire treatment, the record is his property. It is not the property of the hospital or doctor. Then who owns it? It is the same the patient should own. Who prepare? How to prepare? Whatever the doctor has seen, whatever examination he has done, that should be reduced in the writing. If there is no writing, suppose if you have given one question, the alleged medical negligence and no medical records are available. The hospital failed to provide medical record. Write the judgment on this topic. So you discuss on this medical record. If no record, it is negligence is proved. I will come to the next slide. Then how to maintain? Maintenance of the record is also electronic form. You have to maintain. And how long you have to maintain? The OPD records 2 years. The IPD record up to 5 years. If the medical legal records up to 30 years. And if the case is pending before the court, any court, civil court or consumer commission, the record shall be maintained, shall be kept till the disposal of the case. So where is the final disposal? Maybe up to Supreme Court. The record should be preserved. Then how to reconstruct and how to destroy is important. Suppose sometimes you will come across the records are destroyed by the hospital. Then you have to check whether they followed the method of destruction, because hospital has to give the notification. We are destroying the medical records from this period to this period within 1 month. So if anybody want to claim, come within the month. Otherwise, we are destructing the record. This is a valid ground, valid defense for the doctors if the records are not available. I have made the note here different important medical records. It consists of referral note, discharge note, confidential. Then the correcting of medical record is also there, and tampering and destruction. So I will see this, the confidential, the other are discharge note and other. If you find any disparity, you have to you have to decide it goes against the doctors. If no record, definitely that will prove the negligence. What is this confidential? This confidential. The confidential record, medical record, is there are certain diseases. Even in COVID also recently, to declare COVID, it was a stigma. It was a very scary situation, you are aware. The confidential record, suppose patient is HIV positive. You cannot, the doctor shall not declare the communicable diseases also that he is suffering from HIV. So the confidentiality shall be disclosed to the authority or by the order of the court or the very close relative. Then see the quality of document now. I'm coming to that. Quality of document, remember the 6C. If you come across the question, what is the good medical record, or in the medical record you write, the good medical record is, it should be clear, It should be complete. It should be concise. Remember 6C. Then it should be in chronological order. If you see the record, sometimes one date is the date before and latter date will be mentioned first. This is not the good record. Then confidentiality and the client's word should be there. Doctor shall not import his own word or some scientific words from the book. He should write pain in abdomen. That's all. Should not write the colicky or the referred pain in abdomen, because especially in the appendix, it is a referred pain. He shall not write patient said referred pain. No. If the patient is doctor, he will tell. Yes, then next is the see what I was telling, since the absence of medical record straightway concludes, the commission or court will conclude it was a medical negligence. There is no need. Straightway go for medical. If good medical records is a good defense, and poor medical record is a poor defense. Yes. Let us discuss some interesting issues. I think this will, you may get any in the multiple choice question. Urologist perform cholecystectomy, whether it is correct. No, it is not correct. It is a negligence. Issuing medical certificate, it is wrong. Sometimes it will be held against the doctor that it is a negligence or professional misconduct. Advertisement, if the hospital is advertising, we are doing IVF, we are doing ICSI, or we are doing assisted reproductive techniques, and by this patient will be allured, and if something goes wrong, you go through my recent judgment just yesterday, complaint, I remember it is CC 18 of 2010 or so on. It is a IVF case and there is a blunder you go through. It consists of res ipsa loquitur, principle of res ipsa loquitur, principle of vicarious liability, and unfair practices also, misleading advertisement also. I have covered that. Then the res ipsa loquitur, then unscrupulous hysterectomies. You might have aware because of that RSBY, Rajiv Gandhi Health Scheme. The number of hospitals, especially in Andhra, in one village, in one taluka place, almost 70 to 80% women's uterus was chopped off. They underwent hysterectomy. Even the young ladies who have 1 or 2 children, they underwent hysterectomy because the government was paying 35,000. The hospital has targeted all illegal activities and unethical practices happened. This is unscrupulous hysterectomies. It is also negligence. Then the shortcuts. See the shortcut. The medical record consists of number of shortcuts. If you see any prescription, there are shortcuts or dots, or you won't understand. The handwriting of doctor is also not legible. That court will take serious view on that also. Sometimes liability will be faster. Yes, now this is a very important. This covers some aspect of New Consumer Protection Act also. Remember, in the New Consumer Protection Act, the jurisdiction, what you should do, remember, as a now you are appearing for the exam. In the New Consumer Protection Act, you must remember the jurisdiction. The jurisdiction depends upon the consideration paid. It is not the complainant claimed the compensation. Now it is on the basis of consideration paid. If it is up to 50 lakh, it will be district commission, up to 2 crores, state commission, and beyond 2 crores, national commission. Remember this. Second is complainant can file the complaint at his place of residence also, or from anywhere. He may file from anywhere. So this is the second advantage for the complainant. It is a beneficial legislation for the consumer. Now, suppose this slide is for the doctors. I have imported this slide from, it is for the doctors, not for this our discussion, but I have given some points. You may be asked, what is the timeline to file the reply? I think you have gone thoroughly in the New Consumer Protection Act, provisions of New Consumer Protection. And in the previous act, it is 13(2). Section 13(2) was dealing with the to file the written version, the reply. Now it is, I think, 38(2)(a) deals with the doctor or the opposite party shall file the reply within 30 plus 15 days of the receipt of the notice. The 15 days, it is not automatic right, but it is on the application. The bench may reject, but he can avail this right under the provision of this act. Now this, I won't think this is this slide will helpful, but remember the jurisdiction, pecuniary jurisdiction, territorial, then third is to file the reply. What are the provisions under within how many days he should file the reply? So I made some list of few landmark judgments of Honorable Supreme Court and this commission. Sorry, I have not included the recent two judgments which were pronounced on 16th of June. So I request you go through that. It has discussed many principles of the medical negligence, and even 4D has been discussed in those judgments. It is in simple language, you will understand. So I think I am within time and we have time for discussion. Any questions?
Good evening, sir. This was a wonderful session and we are really grateful. It was a pleasure to hear Dr. Kantikar, the former member of a National Commission. We are really rather blessed with the this kind of contribution from Dr. Kantikar. मित्रांनो, डॉक्टर कांटीकर 2 दिवसापूर्वीच आपल्या न्यायिक जबाबदारीतून मुक्त झालेले आहेत आणि त्यांनी ताबडतोब आपल्याकरता हा कार्यक्रमाला यायचं मंजूर केलं, मान्य केलं. त्यामुळे नाव वी आर हॅव्हिंग अ फर्स्ट हँड एक्सपिरियन्स. त्यामुळे मी आपल्याला विनंती करेन की डॉक्टर कांटीकर हजर आहेत, हु वॉज इन द नॅशनल कमिशन. त्यामुळे आपल्या मनातल्या शंका असतील त्या आपण टाईप करून विचाराव्यात आणि सब्जेक्ट टू अवेलेबिलिटी ऑफ द टाइम डॉक्टर कांटीकर मे रिस्पॉन्ड टू सम ऑफ द क्वेरीज. आणि द सेकंड रिक्वेस्ट वुड बी डॉक्टर कांटीकर सर, मुलांना एक 2-3 टॉपिक प्रॉबेबल क्वेश्चन करताचे जरा सांगितले तर ते जरा बरं होईल. दे विल प्रिपेअर ॲट देअर होम ऑन दोज टॉपिक्स की ज्याच्यावरती प्रश्न विचारण्याची शक्यता आहे. प्लीज कंटिन्यू.
हिंट दिली, आता त्यांना क्लिअर कट हिंट दिली की प्रश्न कसा डिस्कस मेडिकल निग्लिजन्स. जर आलं तर तुम्ही लिहायचं आहे, इट इज अगोदर डेफिनेशन ऍक्ट ऑफ ओमिशन ऑर कमिशन, निग्लिजन्स बद्दल लिहा. देन राईट दी ड्युटी. आय फॉरगॉटन ड्युटी बद्दल तुम्ही बोलम टेस्ट एक लक्षात ठेवा. Sometimes you may be asked in the multiple choice question, what is the reasonable duty of care will be decided in these following cases. The Boehm's test, they will put some different. So remember Boehm's test. Boehm's test ही एक रिजनेबल प्रॅक्टिस. डॉक्टरांनी काय केलं पाहिजे, प्रत्येक गोष्ट चुकीची घडली ती निग्लिजन्स नसते. रिमेंबर, दे मे आस्क whether if the patient is not cured, whether it is a negligence of the doctor. No, it is not a negligence. No cure is not negligence. Not referring the patient to the hospital is not referring the patient to the hospital is not negligence. Taking second opinion is not negligence. The negligence, patient will file the cases. The doctor don't know, he referred me, but referring the patient for the bona fide reason is not a negligence. So असे प्रश्न येऊ शकतात. कन्सेंटवर येऊ शकतं. कन्सेंट फार मोठा टॉपिक आहे. कन्सेंटवर जर प्रश्न आला तर तुम्ही विसरू नका की समीरा कोहली आणि मॉन्टगोमरी केस लिहायला विसरू नका. देर आर कॅन्टरबरीज आहे, परत फार केसेस आहेत. बट डोंट फॉरगेट टू राईट समीरा कोहली. समीरा कोहलीची केस सगळ्यांनी वाचावं. मला वाटतं शेवटच्या पॅरामध्ये समीरा कोहली सुप्रीम कोर्टाने डिस्कस केलेले 9 ते 10 पॉईंट. कन्सेंट काय असते, जर कन्सेंटवर प्रश्न फुल क्वेश्चन आला तर यू हॅव टू राईट ऑल दोज पॉइंट. इव्हन आय टोल्ड कन्सेंटचं ते शॉर्ट फॉर्म करून इन्फॉर्म कन्सेंट काय आहे. ब्रँड, इट इज रिमेंबर द ब्रँड इज बेनिफिट्स, देन रिस्क, whether there is alternative or not, whether there is no treatment, you have to discuss and elaborate. त्यामुळे ही स्लाइड, हे प्रेझेंटेशन मी सर्क्युलेट, आपण सगळ्यांना सर्क्युलेट करा ते.
We will do it.
त्यात काही केसेस पण दिलेल्या आहेत. असा प्रश्न येऊ शकतो की फ्री सर्व्हिस म्हणजे काय आणि वाय, वेदर इट इज लाईक. आता रिसेंटली एक जजमेंट आलेलं आहे की ह्याचं जजमेंट आलेलं आहे ते निवेदिता सिंग वर्सेस that has discussed कि free services are not attracted in under Consumer Protection Act. तर या सगळ्या गोष्टी कॅन्डिडेट्सनी बघायला पाहिजेत आणि जस्ट इट इज अ लॉजिकल आहे. डोंट बी अफ्रेड. एखादा प्रश्न येऊ शकतो, एखादा प्रॉब्लेम तुम्हाला देऊन डिस्कस, राईट द मेडिकल निग्लिजन्स जजमेंट असं येऊ शकेल. तर त्यात मेडिकल रेकॉर्ड आहेत का नाही, समजा तिथे ऑपरेशन झालं असेल तर कन्सेंट आहे का नाही, त्या प्रॉब्लेम मध्ये आपल्याला दिलेलं असतं, डॉक्टरने कन्सेंट घेतलेली नाही, ऑर ही टोल्ड व्हर्बली आय विल डू द ऑपरेशन, देन डेफिनेटली व्हर्बल कन्सेंट इज नॉट व्हॅलिड कन्सेंट. सो वेन यू फ्रेम द जजमेंट दॅट टाइम तुम्ही लिहायला पाहिजे व्हर्बल कन्सेंट इज नॉट इटसेल्फ इज व्हॅलिड कन्सेंट. अशा गोष्टी आहेत. आणि मेडिकल रेकॉर्डवर कधी विचारू शकतात. ओव्हरऑल मी जनरल शॉर्ट मध्ये पर्स्पेक्टिव्ह दिलेला आहे. आय थिंक दॅट विल हेल्प द कॅन्डिडेट्स for appearing this exam, and I wish all the candidates grand success, and sometimes I wish to see you on the bench very soon. So all the best. Any questions?
Before our coordinator takes over and proposes a vote of thanks, there is one announcement. आपल्याला माहिती आहे की ही परीक्षा ही MPSC मार्फत घेतलेली नसून IBPS नावाची जी संस्था आहे त्यांना दिलेली आहे. त्यामुळे उद्याच्याला एक विशेष लेक्चर आपण आयोजित केलेलं आहे की जे असे स्पीकर आहेत की ज्यांनी IBPS ची एक्झाम 2 वेळा 3 वेळा त्यांनी सक्सेसफुली पास झालेले आहेत, पण आता ते लेक्चर्स देतात. असे जनरल नॉलेज आणि करंट अफेअर याच्यासाठीचे उद्याच्याला आपल्याला एक लेक्चरर असणार आहेत. Most of the participants have received their admit card किंवा त्यांना आता डिटेल्स मिळालेले आहेत. त्यामुळे तुम्ही अजून जर अभ्यासाला लागलेले नसाल तर डॉक्टर कांतीकरांनी सांगितलं तसं आता जरा वेगात अभ्यासाला सुरुवात करायला पाहिजे, सो दॅट ऑल ऑफ यू or most of you can come on the dais. With this, we are really thankful. I am returning the mic to the coordinator. Please continue. Thank you very much, sir.
Namaste.
Yes. धन्यवाद कांतीकर सर. धन्यवाद. वैद्यकीय दुर्लक्ष व ग्राहक संरक्षण कायद्याच्या सर्व तरतुदी आपण अतिशय सहज, सोप्या व आकलनीय भाषेत समजावून सांगितल्या. आपल्या अमूल्य मार्गदर्शनासाठी आपले शतशः आभार. धन्यवाद सर.
नमस्ते.
धन्यवाद.
थँक्यू.
आणि वाडुंजीकर सरांच्या परवानगीने मी आजची ही मीटिंग इथे कन्क्लूड करते आहे.
ओके, थँक्यू.
ओके.